This is the Construction Leading Edge podcast from constructionleadingedge.com and constructionbusinessaccelerator.com. My name is Todd DeWalt, and it's my job to help you, the construction business owner and leader, eliminate chaos and maximize profitability. Got a great interview for you today with Bruce Inosencio. He is a construction attorney, and you're going to get a masterclass on construction contract law in this episode. You're going to learn some of the risks that you should be looking at, but most don't. Some of the most common mistakes that contractors make with their contracts, how to prevent disputes, some of the recurring themes or most common problems or mistakes that Bruce sees residential builders making, commercial GCs making, and subcontractors making as well. We're going to talk about some of the mistakes with GCs in their owner agreements, and then red flags that you need to look for in contracts. A few big red flags that are non-starters, but unfortunately a lot of people just sign off on. So great stuff. You're going to get thousands of dollars worth of advice in this masterclass from Bruce Inosencio. But before we get into that, I do have a few resources that I want to share with you. One other thing I want to mention is an issue that I hear from contractors on a weekly basis. They tell me things like, Todd, we're busier than ever. I have more work in backlog. I have more employees, but we're not making the money we should, or we're making less money than we have when we had less work, or we're actually losing money. And I'll cut right to the chase. The problem is profit bleeds. There's plenty of profit in the projects, but that profit is bleeding out through a variety of ways. And what you need to do, if that's you, is you need to identify those profit bleeds and then put systems in place to eliminate the profit bleeds. If that sounds familiar to you, if you are losing profit, if you feel like profit is bleeding out of your projects, go back and listen. I want to tell you about two things. One, go back and listen to episode 156, where I walk through 8 profit bleeds that cause really busy contractors to lose money. Secondly, if that's you and you're concerned about that and you want to put together a plan to eliminate those profit bleeds, then let's set up a free strategy call. I would love to get on the phone with you, walk through some of those profit bleeds, and help get you started mapping out a plan to eliminate those profit bleeds. All you need to do is go to my website, constructionleadingedge.com, push the red button that says schedule a free call, and we'll get on a call, talk through those profit bleeds, and help you put together an action plan to stop that bleeding. Let's talk about your bookkeeping for a moment. Are you tired of having inaccurate, incomplete, and confusing books? Are you tired of paying people to help you with your accounting, but not actually getting any useful information? Let me tell you about the Apparatus team. I've worked with them for a few years, and the Apparatus team specializes in one thing and one thing only: transforming your bookkeeping from a, quote, necessary evil and a source of confusion and chaos into a powerful tool that will allow you to grow a profitable contracting business. Think about this. What would you do if you didn't have to do your own books? Would you sell more work? Would you train your people? Maybe spend more time on your boat or in your tree stand? And what if you actually had good information, good accounting information that gave you some visibility into what's going on? Well, here's what the Apparatus team does. They will take whatever bookkeeping you have in place today and completely transform it into the powerful tool that you need to grow your business. So when you become an Apparatus client, they're going to equip you and your growing contracting business with a bookkeeping, reporting, and a payroll system that does 5 things. 1, it's structured. Number 2, it's accurate. Number 3, it's up to date. Number 4, it's clear, giving you useful reports that you can make decisions based on. And number 5, it's accessible. You'll have 24/7 access to all of your books at any time. So if you've had enough of the bookkeeping administrative treadmill or nightmare, and you're ready to have a bookkeeping, payroll, and reporting capability that's going to be the foundation of your successful business, then the Apparatus team is the specialized solution that you've been looking for. To set up a call with the Apparatus team and find out more about how they can help you get rid of your bookkeeping headaches, Go to constructionleadingedge.com/headache. Okay, without further ado, let's get into my interview with construction attorney Bruce Inosencio. Bruce, thanks so much for being on the podcast today. We're going to talk about contract issues, mediation versus arbitration. We're going to extract as much legal advice from you as we can. And here's where I'd like to start. Everybody that's doing construction should have a contract. I won't say they do, but they should have a contract. And here's a question that I've asked in the past. If somebody threw a contract on your desk and said, Bruce, you can only look at, excuse me, you can only look at one part of that contract, one section of the contract. What is the section that you are most concerned about and why?
Well, Todd, first, thanks for having me on. I appreciate the opportunity. And I actually do get questions just like that from time to time. And the first thing I would look at is making certain that the contractor, if I'm representing a contractor, understands the scope of their work. A lot of times, for example, you'll see the word work with a capital W in a contract because it's a contractually defined term. And many times what happens is we'll get into these, we'll start asking questions of our client, and we find that they didn't fully understand or agree with the scope of work that they were actually contractually obligated to provide. And a lot of times it just comes down to making certain that the homeowner, if it's a residential project, or the owner or a general contractor, if you're involved on a commercial project, fully understand and agree with you the relative to the scope of work that's out there. And so it could be as simple as the number of items that you're supposed to provide, the type of items that you're supposed to provide, the start date, the agreed upon completion date, things of that nature should all be readily defined in the scope of work. And that's where people really get into problems, is not having a clearly defined scope at the outset.
Yeah, that seems to be so basic, but so often overlooked, especially most of my experiences in the commercial side. And a lot of commercial projects are fast paced at the beginning, and there's a push to get a contractor on board. So there's a set of drawings that might be 80% done. And then maybe there's bid documents that were issued, and there are a bunch of 8.5 by 11 addenda. And sometimes there are clarifications, and there's this not very auditable paper trail to put it together. So what I found that works really well is assume that somebody like you is going to get involved and audit this project at some point, because frankly, if it ever does get to a dispute or go to arbitration, or if there's some sort of issue, then an attorney is going to get involved, and all they have to go on is what's in the contract. So my advice would be, obviously, reference documents. And it's not just enough to say the contract documents. Let's put drawing numbers and dates on there. And then if there are addenda, let's list those addenda and the dates. And if there's a clarification document, I've even done this in the past where there's some ambiguity, but we need to get a contract signed. Let's put some narrative in there and reference that clarification document, just to eliminate what I call the knowledge gap, where one person thinks something, somebody else thinks you're saying the same thing, but it's the clearer you can be, and the more of the ambiguity you can flush out of it, then absolutely the better. So that's great advice. While we're talking about contracts, what are some of the most common mistakes that you are seeing people make in their contracts? And let's break it down. Let's start with an agreement between a general contractor and the owner. From a contractor's perspective, what are some of the most common, maybe one or two of the most common mistakes that you're seeing people make?
Sure. Well, one of the things that you want to make certain that you're doing if you're the general contractor is finding out whether or not the owner expects that all of your subcontractors are going to be bound by the terms of your agreement with the owner, which is typically the case. Okay. But what happens sometimes is you are in a rush, you're in a hurry, you never share the prime contract between the owner and the GC with the subs and suppliers. And I have a case where this has led to an issue right now where, there's, over $8 million at stake simply because there's a dispute between what the subcontractor thought its scope of work was and what the general contractor believed the sub was going to provide for the owner. And it's all because of a lack of due diligence. People were rushing, I believe, at the outset in an effort to make this project happen. And I don't believe that the subcontractor fully understood the scope of its work, and it was relying upon information that was incomplete to submit its bid. And now it's trying to submit an extra that's 3 times the amount of its original contract price. So as you can imagine, the owner is not happy about that, and the general is not happy about that.
Yeah, and in that case, what would have prevented? What would you have advised them to do to avoid that situation?
Well, I think that the owner did everything that it could have done by having a report prepared by an outside consultant indicating that this was the scope. And I think that the general did everything that it really could have done by offering the subcontractor an opportunity during the bid process to clearly evaluate for due diligence purposes what it was going to have to do. I think the problem is that the subcontractor failed to adequately conduct its due diligence. It didn't understand, for lack of a better term, exactly what it was getting itself into. So this goes back to the work word that's a capital W. What's the scope of work for this particular project? Owner thought it was one thing. The general thought it was pretty much the same thing. The subcontractor had a completely different idea. And so now we have a battle of the contracts. Which contract controls? The one between the owner and the general, or the one between the general and the subcontractor? And so a lot of times what you'll see is you will see a provision in the subcontract agreement between the general and the sub that says that in the event of a conflict between this contract, the subcontract agreement, and the prime contract, the terms of the prime contract shall control. So if you're a sub, you absolutely want to be looking out for that clause, because if you see that, what you really need to make sure that you've done is also carefully reviewed the terms and conditions of the general contract between the owner and the GC to make certain that you understand it and that you agree with it and that you're going to be able to comply with those terms and conditions.
Yeah, I've always been, well, not always, but in many cases, I've been amazed at the lack of due diligence by subcontractors. When I was a project manager on a commercial project, I sent a subcontract agreement out that was in the 6 figures, $400,000 or $500,000 subcontract agreement to an excavation contractor. And I called him and said, Dave, I need this subcontract agreement signed and so I can get you started. And he said, is there anything in there I should be concerned about?
I said, well, that's not the response you should be hearing.
And I said, well, Dave, I would be concerned about all of it. And I'm going to advise you to read it pretty thoroughly. And he said, well, you seem like a pretty good guy. You've been pretty straightforward with us. So I'm just going to sign it and send it back in. And, I appreciate the trust, but I would not advise that level of due diligence. It surprises me how people will go into situations thinking, oh, well, they seem like good guys. They're using emotions and gut feelings to make decisions on matters that will come down to just black and white contracts if there's ever a dispute. Yeah.
Right. Well, it's interesting that you say that because, what I have found is, being a construction lawyer, there are not that many, what you realize quickly is there are not that many attorneys that handle construction litigation or disputes or contracts on a regular basis. And it's a bit of a niche. And so what you'll find is I much more prefer working on these projects with other construction attorneys because they understand the ins and outs already. And so they don't feel like you're trying to dupe them when you raise an issue that is a legitimate issue. They're not having to go through the learning curve. And so my advice to anyone listening to your podcast is if you already have an attorney, great. But if you're going to have a document reviewed, make certain that your attorney actually has some construction contract, construction litigation background. And if they don't, ask them to refer you to somebody that does, just for this limited purpose. A perfect example, I have an attorney here in the town that my office is located in Jackson, Michigan, that he's a friend of mine, and he represents a large school district, and they had a large bond request come through, and there were, pages and pages and pages of construction contract documents on an AIA format. And he quickly realized that this was not something that he handled on a regular basis. And he asked me to get involved. I jumped in and assisted just for that one purpose. He knew I wasn't going to take his client, but he also knew that he didn't know everything that he needed to know for that process. And these can be very complex contracts, and it's not something that someone should just jump into without a lot of thought and background. I know that one of the things that I see pretty consistently when I get involved in projects involving AIA documents is that these documents are often generated such that they're favorable to architects because they are from the American Institute of Architects.
This is true.
And there are, what people don't realize is there are clauses in those contracts that can be easily modified so that they're a little more neutral and more favorable to either the owner or the general or a sub. And if you just take that AIA document as, carte blanche and say, we're going to use this form, this is what we always use, that's a mistake. That can be a very critical mistake. If you don't understand what you're getting into there, I would highly recommend taking the time to go through it with someone that understands AIA documents. And that's not the only entity out there that produces construction documents from a form basis, but that's the one that I would say is used more frequently than not.
Yeah, I would agree. A couple of points there. Whether you're a GC just getting started with AIA documents or you're a subcontractor, wherever you're at, the entity you're contracting with is probably not going to highlight for you the things you should really look at and say, hey, you need to make sure.
You're right.
Look at this. Just because it's boilerplate does not mean it's a good idea. It's like, well, everybody else is using AIA. Well, yeah, there's AIA, but those are editable documents. And I've been on the owner's rep side, and I know as an owner, when I'm preparing a document, I'm protecting my interests primarily and trying to do what's fair. But if it's going to fall on one side of the fence or the other, I'm going to have that risk fall on the other side of the fence because that's my job. And a couple of, back to your point about find somebody who understands construction. A situation I went through a couple of years ago, this was a commercial project. It was a facility being built for a manufacturing company who didn't understand construction, didn't understand design build, and it was about a $10 million facility. And they looked at the architect and said, well, you need to carry $10 million of errors and omissions insurance. And they said, well, we want everybody. We want the general contractor to carry $10 million of general liability and everybody to carry. They would just say, yeah, everybody should have a $5 million GNL or GL policy. And they don't understand how expensive it is to get $5 million of insurance. So from an owner's perspective, somebody can put, if you're an owner's rep, understand that there are a few little key phrases that can be in your contract that can cost you a tremendous amount of money. And the same thing from the contractor side. There are some things in there that could cost you an incredible amount of money. And
I agree. Yeah. One of the things that typically that I see that costs contractors more money than it needs to cost them comes down to extras and change orders and a lack of detail relative to two things. One, spelling out the process in the contract docs relative to how that change order process will work. And then two, implementing it and adhering to that policy. And if you don't have a policy, you need one. And if you do have a policy, you need to follow it, because oftentimes what will happen is you get burned. And I'm not admitted in all 50 states to practice law, obviously, but I'm admitted in Michigan and Florida. And I know that if you have, in those states, if you do work and you don't have a change order for that work, it's a pretty high bar to clear to establish that you're ever going to get paid for that work. Mm. And so if you have not implemented a change order policy that somehow or another provides for you to get paid, you're moving forward at your own risk. And if you're the sub, that's an even greater risk.
Mm. Okay, let's walk through a scenario here. This is one that I've seen a lot. All right, fast-paced project. I'll give you a prime example. Real life example. This same project. It was a manufacturing facility, and the project is moving forward. Work is underway, and the owner comes back and says, "Hey, can you give me a price to put in this special equipment footing?" Meanwhile, everything's going on. They are delaying work in the area of this potential change, and then the owner says, "Just take care of it. It has to be done. Just get it done." And we can't wait on. We don't have time to get a change order, right? I hear that a lot. Mm-hmm. Just get it done, so and we'll settle it later on. And the contractor puts on their superhero cape and says, XYZ General Contracting to the rescue. We're going to take care of our client because we're just get her done kind of guys. And they put $20,000 or $30,000 for the work in. Maybe take on a few days of delay. Maybe move heaven and earth and jump through hoops to try to maintain schedule. And then a month later, they send in their change order request once they get all the final prices from suppliers and subs. And the owner says, "Oh man, I feel like that's too much."
Right.
This happens all the time. In this case, there was a clearly defined change process in the contract that said, don't do anything without a change order.
Right.
So let's talk.
I see that frequently.
Yeah.
So
it's unfortunate.
I had a client that was doing a very large project for a national retailer that was in that exact scenario. And he came to me after the fact. He was already in the process. He did not have an attorney review the contract. And the contract provided that he could not stop work for lack of payment. So right there, that's a red flag. And he could not stop work while waiting for a change order. The contract said that. So he was proceeding at his own risk. He ended up eventually having to file bankruptcy because he did so much work for this customer on this project related to that change. And they, unfortunately for him, crammed it down his throat and said, "We're not signing that change order." And they kept promising him that they would and that he would be involved in their future projects while they were in this growth mode, so on and so forth. And there was also a provision in there that said that even though this project was in Michigan, that jurisdiction would lie in the state of New York. And I told them, you consented to this, you have an argument against it, but eventually you're going to probably end up fighting this battle in New York, and it would be very expensive for him. And it was sad, but this is a situation where he didn't understand what he had signed up for. He didn't negotiate it at all. He didn't have an attorney review it. He was so eager just to get the work that he signed the contract almost immediately, and it ended up running his company right into the ground.
Yeah, and
Very unfortunate.
I've seen that. That could be boilerplate AIA language. You don't have the right to stop work for non-payment. The contracts I've seen give you the right to charge interest for non-payment. So let's go back in time. And if you were reviewing this contract before it got started, what would you advise? And I want to come back to this other situation as well, the how do you actually get paid for the work that you've done? But first of all, what would you advise your client to do when you saw the contract that said you don't have the ability to stop work for non-payment? And I don't remember the other clause, but what would you advise them to do in that case?
So the first thing I would do is point it out to them, and then have them go back to the owner or the GC if it was a GC provision, and just explain that there's no way that this is feasible for you to be able to operate your business in this manner, and that what you'd like to do is limit the amount of exposure. And a lot of people, what I find is they're not willing to give up on these clauses because it's their contract, it's their clause, and they don't want you changing it, which I understand. But I think most people at the outset are also reasonable and will look at something and say, okay, I can see where that might create a problem in the future. Why don't we say that you will continue to work for at least 5 days, but after 5 days, if we don't have resolved it, the project comes to a halt. Because I understand in the speed and pace at which these things operate, and sometimes the slower speed at which documents get processed between the time you're at the office, the time you're out in the field, and the people go back and they review your request, your emails. It takes time. But if after a week you don't have a change order that's signed, you probably shouldn't commit any more resources to this project, or to that change at least. And so what I tell people is, let's see if we can get a reasonable time frame put in here that you can agree to and that they can agree to, so that even if you do get burned in the end on this thing, at least you're not burned beyond more than the number of days that you'd be comfortable working for free. And a lot of times when the other side realizes, hey, there's a time frame that I have to agree to this change order or work's going to stop, you're putting the onus back on them to say, okay, we requested a change order. You asked us to do this extra work. We put the request in. You have 5 days to respond, or we're going to stop. That's how I try to address that situation.
Yeah, another strategy that here's a misconception that I've seen for the better part of the last 20 years. The belief pattern is that before the change order can be approved, the numbers have to be perfect. The numbers, that the accuracy of the change order is the most important thing. And from a risk standpoint, the most important thing is having a change order in place that protects your risk. So my advice would be, one, make sure there's a change order provision in there. And then as soon as they ask for something, give them an estimated cost. And then back that up with the agreement that you'll reconcile the cost based on time and materials or whatever. But get a change order in place that covers, that one, authorizes you to do the work, ties it to some sort of scope of work, makes it part of the contract, and gives you at least puts an estimated value in there that can be reconciled later on. Because again, the most important thing is that there's a change order in place to protect your risk.
I agree.
The most important thing is not that it's the perfect price.
I agree with that, but I think you also, I would add to that two things. First, you want to be certain that when you are submitting the change order, that you're doing so within the time frame that's required by the contract. Yeah. Most contracts will say, as soon as you know that there is an additional cost or an extension of a deadline here, you need to let us know within X number of days. Well, and I have a situation right now where this is going on, where the request is for a $23 million extra, and there was no notification until the end of the project. Well, the change order process is such that if you know that there is a change, which includes either an extension of time request or additional cost, you have to let the owner know within 5 business days.
Mm-hmm.
And my client received no notice of any change order request, let alone, $23 million.
Wow.
So you have to be sure that you're complying with the contract relative to getting your change order in on a timely basis. And the second thing I'd point out is you want to make certain that you're not just asking for additional money, but you are asking for additional time. And I suggest to people when they implement a change order policy that it specifically includes both additional money and additional time, because oftentimes you'll get into this, someone will ask you to do something, and it's not just going to cost you more money, it's going to cost you more time. You're going to have to maybe order more or different materials, or relocate, or remobilize it to a different area of the project, or get different trades back on site. Maybe you want the electricians to come back or whatever. But a lot of times that gets missed, and people don't ask for additional time, and now they failed to meet the deadline because they never asked for additional time. They just asked for additional money in the change order process.
Yeah. Meanwhile, you're carrying general conditions cost, overhead costs, which are very expensive, not to mention the opportunity costs. So if you have a project manager and a superintendent and a team and equipment tied up on one project, they're not working on the next project where they could be doing work and creating profits. So I see this a lot toward the end of projects. Hey, while you're here, can you do this? Hey, while you're here, can you do this? And that $5,000 change order,
common.
It could cost you $50,000 in opportunity cost and overhead and general conditions.
Agreed.
So yeah, absolutely. Every change order should have dollars and days. And this is a misconception that I run into a lot is early in the project, people say, you know what, we can make it up. We can make up those weather days. We can make up the owner delay because it took them 3 extra weeks to sign the contract. And as an owner's rep, I would tell people, listen, if you have to submit a claim for extra time at the first progress meeting that's legitimate, do it. Don't come to me at the end and then tell me, well, this happened all the time. Well, back 6 months ago, they try to recreate history. And to your point, the contract says, look, you have 10 days and or 2 weeks or whatever the window of opportunity is. And it's too late. So here's a situation that I've run into a lot with public projects, and I'd like to get your advice on this.
Sure.
Somebody's working for a school, let's say, and all change orders have to be approved by the school board, right? So this project is moving forward. There's a condition, some sort of unforeseen condition, some additional repair work or demo that has to be done. And so they open up a wall that is supposed to be closed back up in a week, but they find rot or additional framing or some issue. There's a $10,000 issue that is a legitimate change order. The client says, go forward with it. We'll get the change order. We'll put the change order forward at the next board meeting in 3 weeks, but we can't wait. We can't wait for the change order. What should they do in that situation?
Well, I think in that scenario, if you have documents, typically these are in the form of emails or text messages, right? That suggest that you were told to provide a benefit, okay, whether it was continued work or time or material to the project while awaiting the change order, and ultimately it wasn't approved. I think you have an argument. This is the argument I will typically make, that you've provided a benefit to the owner and it's to your detriment. So you have this unjust enrichment argument, okay? The problem with that argument is that in most states, unjust enrichment is not available to you if you are subject to a contract, okay? Because the contract is what is controlling. Mm-hmm. However, nevertheless, many judges will look at that and say, here's the problem. You told them to go forward. You're directing the project. You expect them to wait 2 weeks until a school board is going to meet. And yet, who are they supposed to listen to? The contractor that's on site, the owner's rep, or are they going to listen to a school board in 2 weeks? Because the school board is not the person on site directing them to do anything. And so what it'll come down to oftentimes is the court will have to make a decision. Did the contractor do what was legally required under the contract, or did they do what they were asked to do by the person on site that they were receiving their direction from? And what's the appropriate thing to do here? So that's a tough call. But oftentimes, if you have emails or text messages that can substantiate the request, most times the judge is going to look at that and say, hey, I'm going to go ahead and award the dollars. The problem that you get into is court is very expensive. And you alluded at the beginning to, mediation or arbitration. I try to keep my clients out of court as much as I can. I love litigating cases and trying cases and being in court. I truly do. But I also tell my clients it's very expensive and there's risk. And so the best thing to do is to resolve disputes before you get to court. And I find mediation is the most effective way to do that. And I typically require my clients to include mediation clauses right in their contract documents. And what happens is you end up going to mediation if you can't resolve a dispute between the principals of the parties that are involved. You go to mediation before you end up in arbitration or litigation. So it's a faster, cheaper way to resolve the dispute, and you're not having to attack it with a vengeance like you do in court. I mean, as soon as you file a lawsuit, people are typically digging in their heels, they're becoming entrenched in their positions, and you're looking at it as either though you're on the attack or you're being attacked. And mediation, you're going into it with an idea that you're attempting to work together to reach a resolution. And that's a big difference.
Yeah. And so let's talk about that situation. Certainly you want to cover yourself, but ideally it wouldn't go to any sort of dispute resolution, because not only is that slow, that means you're, from a cash flow standpoint and from a risk standpoint, you're financing the work, hoping that you get paid. So other than having text messages and emails that you can use to back up your position in court or in some sort of dispute resolution, what if they just said, you know what? No, I have a contract, and if it hits the fan, then I'm going to be bound to this contract. So no, I'm not doing that extra work until you get me a change order. Then what would happen? I have sent that letter many times for clients that specifically says, we've reviewed the contract. We understand your willingness and your eagerness to accomplish this task, and we're willing to take care of it for you. But the contract that you required us to sign is actually obligating us to get a change order. It's your contract. Right.
If you want to waive that provision, we're willing to do that. But as it stands right now, we can't do this work with any guarantee of payment until you provide us the change order. Mm-hmm. And many times you'll end up getting a change order.
Yeah. And I would also add to that, if you choose not to give us a change order, so option one is give us a change order. Here's the estimated cost. Maybe it's, we need a change order to cover the estimated cost, which will be reconciled later. Or option two is we wait until the formal change order is approved, which will involve additional time. It's going to delay the project, additional GCs, additional costs, remobilization, whatever it is. So so doing the work without a change order should not be an option. My advice would be to, option one is you give us a change order now. Option two is, here's what it looks like to wait for a change order. But under no circumstances will we proceed knowingly against the terms of the contract that you gave to us to sign.
I agree with you, with the one caveat. The problem that I see is this. Not every one of my clients that are in that situation can afford to hold people off. And they're so dependent upon the work or completing the work so they can get to their next project, that they just go ahead and they cave, even if I advise them not to.
Yeah.
And so that's where you start seeing these problems, is when the situation is such that, they've done this on a handshake in the past and it's always worked out well. And then what you find out is this isn't the owner that you've dealt with in the past. It's the same GC, but they have a different owner. And this owner is more of a stickler for this, and they're not going to pay for it. And the GC cannot convince the owner to pay for it. And now the owner is not going to pay, and the GC isn't going to pay. So the sub pays by not getting paid. And so that's where it becomes really a problem for specifically smaller companies that get into these things more often than not, because they don't have the leverage of a larger entity.
Yeah, it's unfortunate, but the reality is, if somebody is trying to get you to take a risk of doing extra work without a change order, you don't have to say yes. And you have other options available. Yeah, I can tell you, here's an example. I'll give you a quick synopsis of a project that I was brought into to finish out. This was a project for a municipality. It was a stormwater project that involved putting stormwater utilities in a street. And there was a set scope of work. It was a unit price contract. And they got started with work, and the engineer who was managing the project deleted a bunch of one type of work and then started adding a bunch of other work. Well, the contractor was just chugging along saying, sure, we'll just do this a significant amount of extra work. And then there was a flood. It was close to the Kentucky River, and the area flooded. And there was no work that could be done for 2 weeks. Nobody submitted a weather claim. Everybody sat at meetings and said, yeah, you couldn't work for 2 weeks, and it was bad. And then 9 months into a 12-month project, they were about they were just about out of their contracted time. They had completed about 50% of the work, and the city attorney got involved and said, hey, according to the contract, your time is about up, and you're going to start racking up liquidated damages. And everybody said, wait a minute, we had these meetings, and the meeting minutes said this, and we talked about this, and everybody was looking at each other, but nobody submitted a change order. Nobody made a claim for additional time. There was a 10-day window of opportunity to make that claim. Nobody denied the fact that it flooded. Nobody denied the fact that there were additional charges. And on top of that, the engineer said, well, we want you, even though the engineer had made all these changes, the engineer said, well, you're going to have to compensate us for additional construction administration time as well. So that contractor, I negotiated as much as I could, but that contractor got hit with $76,000 of liquidated damages just because they didn't submit claims for additional time because of floods and all these other delays, owner delays, floods, all very legitimate. But that particular clause in the contract cost them $76,000. Yeah.
Yeah. So, I see those type of instances. And a lot of times what my client will tell me, if they're on the bad side of that, is, I didn't fully understand that.
Yeah.
Well, my advice is this. Don't go forward with a contract unless you do fully understand what it is that you're getting yourself into. And don't be so prideful that you're not willing to get assistance or advice from somebody else, either on your team or a construction lawyer that can walk you through all of this step by step. And I tell my clients when I'm reviewing these contracts with them, listen, I know that you probably know this stuff, but it makes me feel better to sit down, go through it with you, make certain that you understand some of these critical issues so that you don't get burned. And most of my clients find that that's time well spent, because they're now looking at it from a different perspective. They have a much wider approach to avoiding risk as they go forward. And it kind of trips them into a risk-averse mode. They don't just look at a situation anymore and say, oh, that's okay, we'll just roll with it. It's reminding them, wait a second, there's something in my contract that talks about that. Many times these things are signed, they're thrown in a drawer or scanned into a Dropbox folder and forgotten. And that's fine as long as everyone gets along and everything goes smoothly. But this is construction. And that doesn't happen that very often, that a project goes 100% exactly as it should. That's the exception, obviously, rather than the rule. And so it's helpful to sit down with someone at the outset, go through these contracts, make sure that you understand them in their entirety and that you are recognizing situations as they develop, and then recalling that your contract likely has an impact on the outcome.
Yeah, in other businesses, there are special consultants like cybersecurity consultants who will be brought in to do what's called red teaming. They'll red team a business and try to find all the threats and hack into their systems. And I would recommend red teaming your contract. Have somebody look at it from the lens of, all right, this thing is going to go to court. Assume that there's going to be a dispute. So let's look at, let's red team this and find the areas like payment clauses and pay when paid clauses, and how do we handle changes, and what about schedule delays? And I've had situations where the definition of a weather delay was subject to interpretation. And after you have incurred 30 days of weather delays is not the time to interpret that. So red team it, look for ambiguity, bring it up to the owner before you sign that contract. But I think you've mentioned it several times, and I've seen it over and over. People are in such a hurry to get that contract that they look at it with rose-colored glasses instead of through the loss aversion, the risk aversion lens, and they rush into it hoping and assuming everything's going to go well. And unfortunately, that is just not the case. So we've got a few more minutes to talk about. I want to talk about some recurring themes. You have the benefit of the unfortunate vantage point of seeing things when they go wrong. I assume a lot of people don't call you and say, hey, this went great, Bruce. I just wanted to tell you all about it. It's probably when things don't go all that well.
So that's true.
You have a bit of a negative view on construction than some. Let's talk about recurring themes. I want to talk about 3 specific types of contractors. What are some of the recurring themes that you see, recurring problems that are easily avoidable, starting with the residential builders?
Sure. First thing, inappropriately completed sworn statements and processing of lien claims. Happens all the time. And what happens specifically is contractors don't fully understand how to complete a sworn statement, and then they sign it under penalty of perjury, and they created a huge problem for themselves. And what I see oftentimes is I will be involved in a residential construction dispute, and someone will bring a sworn statement into me. Either my client is the general contractor or my client is the homeowner, and I'll look at it and it's filled with a bunch of numbers that all end in 0. And there's no way that every specific subcontractor on this project was paid X $1,000 or X $100. And what's happening is the general contractor is just putting in whatever numbers work for them, as opposed to listing the actual costs paid to the various subcontractors and suppliers. That's what you have to do. And your claim of lien is going to be impacted negatively unless you've properly completed the sworn statement. And I see that problem over and over again. And, I'll have someone, I just had a client of mine, tell me this 2 weeks ago. Well, the roofing on this house was actually 10 grand, but I put down 12 to include my profit and overhead. That's not appropriate. That's not the right way to do it. The right way to do it is to list to the penny the actual amount that you paid to the roofing contractor for their lien waiver. And then the overhead markup is in a different line item called overhead. And you've appropriately spelled that out, hopefully, in your contract, so that the homeowner already knows you're going to make money on the project. That's what you're there for.
Mm-hmm.
You're there to complete a project. You're there to make money, and you should be itemizing that in your sworn statement. If I'm representing a homeowner and a residential builder has filed a claim of lien, one of the first things I will do, if not the first thing, is say, I want to see all the sworn statements and lien waivers. And many times they do not match. And that's a significant problem if you're trying to make sure that you have your lien rights in place on a residential construction project.
Good stuff. What are some recurring themes that you see with commercial general contractors?
So commercial general contractors, I would say the first thing that I look for is making certain that all of their subcontractors are also subject to agreements. One time, I can think of a large project I was involved in probably about 5 or 6 years ago, where it was a very large project, and the main contract here, the prime contract between the owner and the general was, I don't remember exactly, but maybe 60 pages long. It was pretty lengthy. And some of the subs on that project didn't even have an agreement. And some of the subs on the project had a 1 or 2 page agreement. And there's no way that the scope of this project should have resulted in either no agreements with some subs or 1 or 2 page agreements with others. There's just too much going on. There's too much at stake. And so a lot of times what will happen is a subcontractor will get involved. It's with a GC that they've had a long relationship with. They come along for the ride, and they just don't do what they should have done from a contracting standpoint at the outset. And so that's where you can get into some significant problems, is by not having a detailed contract with very detailed specifications.
What about subcontractors? What are some of the most commonly recurring issues you are seeing with subcontractors that could be easily avoided?
So one of the things I see many times is indemnification clauses that are included in subcontract agreements, where a subcontractor agrees to indemnify and hold harmless the general contractor in the event that their work is somehow scrutinized. Now, for people that are listening that don't understand that whole process, when you agree to indemnify somebody or an entity, what you're agreeing to do is defend them in the event that they're sued. So that means you are on the hook for the attorney's fees associated with defending them. And what happens oftentimes is those indemnification clauses will just say that in the event that the general contractor is sued by the owner, that the subcontractor is responsible for indemnification and will hold harmless, which means they'll pay any damages in the event that the general contractor is sued. Well, my recommendation there is to make certain that you are narrowing the scope of that indemnification as much as possible. It's likely that you won't get out of indemnifying the general contractor altogether, but you should not be indemnifying them for any work that's outside of your scope, that's any work that's outside of your control, or any damages that you had nothing to do with. And a lot of times I will see subcontractors that have signed agreements that include these extremely broad and unnecessary indemnification clauses that are resulting in them buying more risk than what they ever anticipated.
Good advice. Lots of probably increased heart rates right now of the people who are listening thinking, oh my gosh, what did I sign up for? So here's a question. Somebody, let's say there's a listener who's flipping through their contract right now, or they're calling their office saying, look at my contract, and they realize I've signed up for something that I didn't think I signed up for. Obviously, the next time when there's another contract to sign, there's an opportunity to strike those clauses and do some edits. But what, if anything, can they do if they're in a situation and there's some clause in their contract that is pretty scary?
So here is one thing to potentially look out for. If you are not the person or entity that drafted the document, you might be able to take advantage of this legal doctrine called contra pro forentum, okay, which is Latin for against the drafter, okay? So earlier you mentioned the possibility of an ambiguity in a contract. And for those that don't understand that, that just means that there is a clause in the contract that could be interpreted more than one way. So let's say, for example, the contract that you provided me, you're the owner, and you say that as the general contractor, Bruce, you're going to install 6 turbines in my power generation facility. But we don't talk about the output that those turbines have to meet. We left that out of the contract. And we also didn't talk about the size or the manufacturer. So what's the problem here? Well, the problem is we have an ambiguity. You might think that those turbines are supposed to be X. I might think they're supposed to be Y. Anytime you have an ambiguity in the contract, there is a potential that that ambiguity might be construed against the drafter, hence the phrase contra pro forentum. Because as a matter of public policy, courts don't want people drafting contracts, creating an ambiguity in those contracts, and then being able to take advantage of that ambiguity. So courts will often say, well, if you drafted the contract and there's an ambiguity in the contract, we're going to construe it against you and in favor of the other side. That way we know that you'll do a better job next time of not including clauses that are ambiguous. So what happens sometimes is you'll look at a situation and say, hey, I didn't think I signed up for this. And you kind of can walk through and get an understanding of why that person might have believed they didn't understand that they signed up for that, they signed up for something else. And if there truly is an ambiguity, depending on the state that you're in and depending on the current status of the case law that is in effect at that time, you might be able to say that, hey, I didn't draft this document. It was a form document that was sent over to me by the attorney for the owner or the attorney for the general contractor, and it was negotiated, but I didn't draft it. And there's an ambiguity in here, and it should be construed against the drafter. You can sometimes take advantage of that.
Good advice. Good advice. Well, I appreciate all the time. I want to be a good steward of your time, and I think we're probably pushing our limit here. But thanks for basically a masterclass in construction law, especially construction contract law. A lot of great nuggets here. If people want to get in touch with you or connect with you, where's the best place for them to go? What are some links that I might include in the show notes so people can find out more about what you do and contact you?
Sure. Yeah, they can either send me an email, and my email address is Bruce, BRUCE, at Inosencio.com. That's INOSENCIO.com. Or they can check out our firm's website, and that's InoSencioFisk.com. It's INOSENCIOFISK.com. And if that doesn't work, you can give us a call. And our numbers are there. You can put that in the show notes as well. I can give those to you. But we're happy to talk to people about their construction contracts. And the best thing to do is to get a solid contract before you start a project and understand that contract and what really could be negotiated and what shouldn't be negotiated away to make sure that you're protecting your rights.
Great advice. Thanks a lot, Bruce. I appreciate it.
You're welcome. Thanks for the opportunity, Todd.
Well, I hope you got a lot out of that interview with Bruce. Make sure and look at your contracts. This is a good time to pull out the contracts that you're working under right now and look for those red flags, and then make sure and watch out for the red flags on the projects that will be coming up. Don't forget, if you want to offload your bookkeeping, payroll, and accounting headaches, your reporting headaches, then check out the Apparatus team and what they can do for you. They are helping lots of other small construction business owners offload their financial headaches right now. So you can go to constructionleadingedge.com/headache to find out more and take the first step with the apparatus team. If you want to eliminate profit bleeds in your business, then I want to help you. What you need to do, if that's you, is schedule a call with me, and we'll talk about what are some of the biggest profit bleeds you're dealing with, and then start to map out a plan of attack so you can plug those profit bleeds and keep more of the profit that's in your backlog. The first step is to schedule that call by going to my website, constructionleadingedge.com, and clicking the red button that says schedule a call. As always, I appreciate the ratings, the reviews. If you could take a moment to leave a rating and a review on Apple Podcasts or the podcast player of your choice, that helps get the word out there. If you could share this with somebody else who would get some value out of it, I would appreciate it. As always, thank you so much for listening. My name is Todd DeWalt. I'll see you next time.